I'm Adam Winkler. I'm a professor of law at UCLA School of Law here in Los Angeles and the author of Gunfight, the Battle of the Right to Bear Arms in America. As most Americans know, the language of the Second Amendment is maddeningly ambiguous. It says, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. It's almost like Madison, who wrote that provision, finally discovered the comma and wanted to put as many of them as he could within that text. But as a result of all those commas, it's kind of unclear exactly what the Second Amendment was designed to do, at least on the face. And the Supreme Court was facing two competing interpretations, really. One interpretation, which had traditionally been adopted by the federal courts, was that the Second Amendment protected the right of state militias to be free from federal interference. So the federal government could not disarm the state militias. A competing view has arisen, and in fact has been in American dialogue and political debate since the founding, which was that the Second Amendment protected a right of individuals to own guns for personal self-defense, totally apart from service in a state militia. So the Supreme Court was really charged with sorting out which of these two views of the Second Amendment is the right view of the Second Amendment. And the court, in a landmark decision, held that the view that the Second Amendment protects an individual's right to bear arms was the correct one. Well, the court got there through what was purportedly an originalist methodology by the lead proponent of originalism in the Supreme Court, Justice Antonin Scalia. He wrote the majority opinion for the Supreme Court, a 5-4 decision in the Heller case, striking down that D.C. gun law. And he got there mainly by looking at history, by saying, when we look back at what the Founding Fathers intended, they intended that ordinary civilians be armed. The Founding Fathers were very much opposed to the idea of a standing army. And this has reasons to do with the traditions that they were used to in England. They thought a standing army would be used by the king to control the people, to disarm the people and provide a security force that he would use to tyrannize we the people. So when the framers wrote the Second Amendment and referred to a well-regulated militia, they were talking not about a standing army, they were talking about a citizen militia. We the people called out to arms to defend our nation and to fight. And the framers believed that civilians with guns would prevent government from becoming too tyrannical. Well, there's so many different issues that he had to address. What does the Second Amendment mean by the right of the people to keep and bear arms? Did that mean the people as a collectivity? That's what the militia theory had argued, that we the people come together as a collectivity, act in the militia to protect our liberties. However, Justice Scalia said, well, if we look at the way the phrase the people is used throughout the Bill of Rights, in the First Amendment, it says the right of the people to peaceably assemble. We don't interpret that to mean anything other than an individual right of persons to associate and organize for political reasons. When the Fourth Amendment says the right of the people to be secure in their homes from unreasonable searches and seizures, we don't interpret that as a collective right. We interpret that as the right of individuals to be free in their own home from government overreaching. So he says, well, we must understand the people in the same way in the Second Amendment as we understand it in the Fourth Amendment and the First Amendment and in some other provisions of the Constitution. We interpret those really as a reference to the people having individual rights. And there was disagreement among this view. Justice Stevens, in his dissenting opinion in the Heller case, argued that we the people was a collective reference and wasn't quite the same as the Fourth Amendment or the First Amendment. Justice Stevens and Justice Scalia disagreed on a number of other textual matters in the Second Amendment. What does it mean to keep and bear arms? Justice Scalia said that's an individual right to have an arm in your home for self-defense. Justice Stevens said That's a right that's associated with military service. You bear arms in a military context, not outside of a military context, in his view. And so they disagreed on many aspects. Almost every word of the amendment occasioned some disagreement between the two contending sides. Sure. No good Supreme Court opinion goes without a number of concurring or dissenting opinions. Justice Breyer's opinion was a dissenting opinion. He sided with Justice Stevens, but wrote for himself to suggest that regardless of the nature of the right to bear arms, whether it's an individual right or a collective right, that there must be ample room for states to carve out gun control laws, and that he thought that the District of Columbia was well within its rights to ban handguns, which are a type of firearm often used in crime. The vast majority of criminal acts committed with a firearm are committed with a handgun. They do a lot of damage, easy to conceal, easy to transport around. So Justice Breyer thought that the court should balance the right versus the ability of cities and states to protect public safety. Well, they are, but they're not. So on the surface, Justice Scalia's opinion seems like the real embodiment of originalism. And in fact, right after the decision came down, it was heralded as a triumph of originalism, the crowning achievement in Justice Scalia's decades-long effort to make originalism, not living constitutionalism, the foundation of constitutional meaning today. But as I argue in Gunfight, actually his opinion's quite a bit more complicated than that, and in very important ways seems to adopt a living constitution approach. There's a really important paragraph towards the end of Justice Scalia's opinion where he says, nothing in this opinion should be taken to cast doubt upon long-standing prohibitions like bans on felons or the mentally ill from having firearms, laws restricting guns away from sensitive places like schools and government buildings, or commercial sales restrictions like background checks and things like that. And that is an important paragraph because when interpreting the Second Amendment, we must do more than just identify the nature of the right. We must use that amendment to try to figure out what are the exact limits on what government can do. Can it pass this law? Can it pass that law? That's where the rubber hits the road in constitutional analysis. And Justice Scalia, by saying that laws banning felons and the mentally ill and laws banning guns from sensitive places, laws restricting commercial sales, by saying those things are all legitimate, the court was not embodying an originalist methodology because none of those kinds of laws were in existence when the founding fathers wrote the Second Amendment. Those laws trace their heritage mostly to the 20th century and are a result of modern day regulation. So in many ways, Scalia's opinion turns out to rely on the same kinds of living constitutionalism that Justice Scalia inveighs against so often. I don't think that there are distinctions without a difference, and I think one of the important differences they might have is in terms of public debate. I think that if the Supreme Court had said that the Second Amendment does not protect an individual right to bear arms, it would lead to a lot of unhappiness. It would lead to a real reinvigoration of the gun rights movement. It's already a strong movement in America, but I think you'd see a much more powerful movement. In fact, there were some who suggested that the election in 2008 of Barack Obama might have been very different had the Supreme Court that summer held that the Second Amendment did not protect an individual right to bear arms, because it might have stimulated gun owners who are known to turn out in force for their favorite candidates to really show up and give more support to John McCain, who they imagine might have pushed for justices more friendly to the individual right to bear arms. So there are differences in a variety of ways, but one of the distinctive features of Scalia's opinion that people often miss is how it did carve out plenty of room for states and localities to enact gun control laws. And indeed, to this day, there have been well over 200 federal court decisions on the constitutionality of gun control since Heller was decided. The vast majority of them uphold the challenge gun control laws. Only a very, very small number of laws have been called into question. Well, I think for the vast majority of gun control laws that were politically feasible, and I guess that's a small number these days, there's really no effective difference. The court's not going to strike down the laws, and these laws, whether they get passed or not, really doesn't have much to do with the Second Amendment per se. I think there's a big implication in the Heller case that might be positive for the gun debate more generally. I'm hopeful that by clarifying that the Second Amendment protects an individual right to bear arms, that government can never come and take away all of the civilian guns, that might quiet the gun debate in the long run. That maybe in the long run, gun owners will not feel that every gun control law puts us on a slippery slope towards disarmament, because the Supreme Court hopefully will say repeatedly that government can never take away all the guns. And if they do that, I think there's a lot of gun owners out there who would support laws that gun control organizations call common sense or reasonable gun control laws, things like um, extending background checks to all gun purchasers, restrictions on the most dangerous types of weapons, other kinds of laws might be supported by many gun owners who today refuse to support them because they're afraid of losing their right to bear arms entirely. So I'm hopeful that Heller points a way to restore some balance into the gun debate and maybe help us break the current stalemate over guns in America. It's so hard to say what was in the minds of the justices when they write their opinions. All we really have are the opinions themselves. Maybe years later we'll get some draft opinions that'll provide more answers as to exactly what they were thinking when they wrote the opinions. But I think it's clear to any student of constitutional history that over the course of American constitutional law, our interpretations of this fundamental charter have shifted and moved with social movements, with changes in understanding about how we think about the different phrases. There is no question that the framers of the 14th Amendment in the 1860s, passed right after the Civil War, did not intend the guarantee of equal protection of the laws to outlaw racially segregated schools. Now, we know that because they had racially segregated schools at the time, and even the most liberal progressive state, like Massachusetts, had racially segregated schools. And no one at the time ever suggested that the 14th Amendment outlawed racially segregated schools. It wasn't until about 80 years later that the Supreme Court held that, indeed, the 14th Amendment protected the right of individuals to be free from race discrimination in places like public schools. And that's a result of the civil rights movement. It was a result of World War II and how our experience in World War II changed fundamentally our understanding of the harms of race discrimination. So there's no doubt that the law moves and shifts with social movements and with development of ideas. And I think there's no doubt that in America today, the view that the Second Amendment protects an individual right to bear arms is very well accepted, very well established. And even if you believe in a living constitution, I think you should agree that the Second Amendment protects an individual right to bear arms. Thank you very much for having me.